Welcome back. Now that we have already understood what a contract of sale is and how goods are defined under Sale of Goods Act 1930 and also about the conditions and warranty, the next question is, when does the ownership in goods pass from the seller to the buyer? Now, this is an extremely important question because ownership, that is, property in goods, decides who bears the risk of loss, who can sue a third party for damage to goods, and who has the right to claim delivery. Now, let's understand this clearly. The transfer of ownership means the transfer of general property in goods from the seller to the buyer. Once the ownership passes, the goods become the buyer's goods and any loss or damage is generally the buyer's responsibility. So, as we move ahead, keep asking yourself this question. At this point of transaction, who is the real owner of the goods? Now, this question will guide you through the entire chapter. Now, let us understand the rules of transfer of ownership. So, first, we deal with understanding transfer of ownership in case of specific or ascertained goods. Now, as already explained, specific goods are those goods which are identified and agreed upon at the time of contract of sale. So, what is the general rule? General rule is ownership passes when the parties intend it to pass. Now, what do you mean by intention? How can anybody know the intention of the parties? So, here the Act gives us four guiding rules to identify the intention. So, rule number one, if the specific goods are in a deliverable state, then the ownership passes at the time of contract itself. For example, A agrees to sell his bike to B for rupees 50,000. Now the bike is fully ready and nothing more needs to be done. Now in this case, this is a specific good which is already in the deliverable state and hence the ownership passes immediately when the contract is made. So, keep this in mind. Goods are identified, it is ready, ownership passes immediately. Okay. Now let's understand rule number 2. Rule number 2 is when specific goods are not in a deliverable state. Now, in such a case, ownership passes only after the seller does something to make them or to put them in a deliverable state and the buyer has a notice of it. Very important, the buyer should also have the notice after the putting the goods into a deliverable state. Now, for example, A agrees to sell a machine to B. The machine needs some repairs before delivery. Now, in such a case, the ownership will transfer only after the repairs are done to the machine and also B is informed about the repairs done. Okay, so after understanding rule 2, we can understand that readiness of goods is also a crucial condition. Now, let's move to rule 3. What is rule 3? If specific goods are in a deliverable state, but the price depends on weighing, measuring, etc. So, what happens here? Even if the goods are in a deliverable state, but something must be done in order to ascertain the price. Now, in such a case, ownership passes only after that act is done and buyer is informed. For example, A agrees to sell rice to B at rupees 60 per kg. The rice is packed but not yet weighed. So here the ownership passes only after weighing the rice packet and also B is informed about it. So here we can understand deliverable state is alone not enough. Even price must be finalized. Let's understand Rule 4. Rule 4 is regarding the goods when delivered on approval basis or sale or return basis. Now, here the law becomes more practical and relatable. Now, in such a case, ownership passes when the buyer expressly accepts the goods because the goods are delivered on approval basis, or the buyer does the same act adopting the transaction, or the buyer keeps the goods beyond the agreed time or reasonable time if no time is fixed. For example, A delivers a watch to B on sale or return basis for 7 days, and B uses the watch for 10 days without even returning it. Now, here the ownership automatically passes after 7 days. Okay, so what you can understand here is from certainty of goods, we understood how readiness becomes important. From readiness, we understood even price determination is important. And finally, we are now understanding even the buyer's approval is important for the ownership to transfer. Okay, now this was rules regarding understanding how the ownership transfers in case of ascertained and specific goods. Now let's understand how the ownership transfers in case of unascertained goods. Now, what are unascertained goods? As already explained, unascertained goods are not identified at the time of contract. Now, the general rule is ownership passes only when the goods are ascertained. Now, this is logical because you cannot become the owner of some goods from a big lot unless they are clearly identified. For example, A agrees to sell 10 bags of rice out of 100 bags. Now, the ownership passes only when those 10 specific bags are separated from the lot of 100 bags. And that means you have identified the 10 bags. So, if there is no identification, there will be no ownership. Okay. Now, let's understand transfer of ownership in case of goods sent on approval. Now, ownership passes when the buyer accepts the goods, does any act adopting the transaction, retains the goods beyond the agreed or reasonable time. Okay, so once again we see that ownership flows with the intention and acceptance. Okay, now comes a very important protective provision for the seller. What is that? Sometimes the seller wants to retain the ownership until the complete payment is made. So, the seller may reserve the right of disposal by making ownership conditional, sending goods through a transport document in his name. Okay. For example, A sends goods to B through a railway receipt made in A's name itself. Now, the ownership does not pass to B until the payment is made. Okay. Now, what we have understood? We have understood that risk follows ownership. This is the general rule. What is it? I will repeat again. Risk follows ownership. Okay. Now, sometimes risk also passes to the buyer. When the ownership passes, risk passes to the buyer. So, for example, if goods are destroyed after ownership has passed, the buyer bears the loss even if delivery is pending. But remember, parties can always agree otherwise through an express contract. So, pause and reflect. Ownership decides the risk, but agreement can override the rule. Okay? Now that ownership is clear, the next logical question is how are the goods actually delivered? And in my previous video, I have already covered the meaning of delivery, which means delivery is nothing but voluntary transfer of possession from seller to the buyer. And we have also understood about the different modes of delivery, which is actual delivery, constructive delivery, and symbolic delivery. So, with this, we can summarize that ownership is about rights, whereas delivery is about physical control. Both are different, but it is connected. Okay, but let's understand some rules regarding delivery of goods. Okay, so the first question in any sale is, where will the goods be delivered? So the law says, if the parties have agreed on a place of delivery, then the delivery must be made at the agreed place. Now pause for a moment and think. In most commercial contracts, the place of delivery is clearly mentioned, correct? So, the law simply respects the agreement of the parties. But what if the contract is silent? Now, in such a case, the rule is delivery shall be made at the seller's place of business, and if the seller has no place of business, then it will be made at his residence. For example, A agrees to sell goods to B, but the contract does not mention the delivery location. Now, let's say A runs a shop in Delhi, then B must take the delivery from A's shop in Delhi. Okay, then let's understand the next condition regarding delivery. Once the place is clear, the next question is, by when should the goods be delivered? Now the law again follows the same pattern. If time of delivery is fixed by the agreement, the delivery must be made within that time. But however, if no time is mentioned, then delivery must be made within a reasonable time. Now, this word reasonable is very interesting. It does not mean one fixed number of days for all cases. It depends on the nature of goods, market practice, distance, urgency of the transactions. For example, if you order fresh vegetables, reasonable time may mean the same day. And if you order for a machinery, reasonable time can mean a few weeks. So the law allows flexibility while still ensuring fairness. Okay. Now let's imagine a slightly different situation. Now sometimes the goods are not with the seller but with a third party, like for a warehouse, or it can be with the transporter, or maybe it can be with the bailee. Now in such a case, delivery is complete when the third party acknowledges to the buyer that he now holds the goods of the buyer on buyer's behalf. Okay, so delivery does not require physical movement every time. It can also happen through legal acknowledgement. For example, A sells goods to B. Now the goods are lying in a warehouse. Now the warehouse keeper informs B, I will now hold these goods on your behalf. Now delivery is complete at that moment. So we move from physical delivery to legal delivery through acknowledgement. Okay. Now let's talk about money involved in delivery. Now the general rule is what? The general rule is the seller bears the expenses of making the delivery. This includes your cost of packing, cost of loading, cost of weighing, cost of measuring. All of those are included when I say seller bears the expenses of making delivery. But again, the law respects the agreement of the parties. So, if the buyer and seller agree that delivery expenses will be borne by the buyer, then that agreement will prevail. Okay? For example, if a contract says delivery charges extra, correct? Then the buyer will bear the delivery expenses. So, the smooth logic here is seller pays by default because that's the general rule. But however, if the agreement is otherwise, then it can change. Okay. Now, let's deal with a very practical issue. What if the seller delivers more goods than what is ordered, or maybe less goods than what is ordered, or maybe mixed goods? Okay. Now, the law gives protection to the buyer. So, if less quantity is delivered, the buyer may reject the delivery or accept it but pay proportionately. Okay. And what if excess quantity is delivered? Then the buyer may accept the agreed quantity and reject the extra which is delivered. Or the buyer can actually reject the entire or the whole delivery. Okay. Now, what if goods are mixed with different goods? The buyer may accept the goods as per the contract and reject the other goods which he had not agreed for. Or he can also reject the whole delivery. For example, B orders 10 bags of cement and A delivers 12 bags. Now B can either accept 10 bags and reject the remaining extra 2 bags, or he can reject the entire 12 bags. So, notice how the law protects the buyer from forced acceptance. Okay? Parts. Now, the general rule is the buyer is not bound to accept delivery by installments. Installment delivery is allowed only when it is agreed by the parties. So, for example, if A agrees to sell 1000 units to B and no installment clause is there, A cannot force to B to accept 100 units every month. Okay, so here again agreement is the king. Okay, now comes the buyer's responsibility. Now the seller is not required to send goods on his own unless the buyer applies for delivery. So the buyer must make a request or demand for delivery. For example, if B buys goods from A but never informs A to deliver them, A is not at fault for non-delivery. So, delivery is a two-way responsibility. Okay? And finally, we complete the circle. Once the buyer applies for delivery, it becomes the seller's duty to deliver the goods as per the contract and legal rules. The seller must deliver the correct quantity at the right place within the right time and also in the agreed condition. So notice how the beautiful balance is there in law, where the buyer must apply for delivery and the seller must deliver properly. Now both sides have duties, but both sides are also protected by law. Okay, so before we conclude this video, ask yourself all of these questions and see if you can answer them. Who bears the delivery expenses by default? Can a seller force installment delivery without agreement? Now, is physical movement of goods always necessary for delivery? Now, if you are answering all of these questions confidently, you are absolutely on track with this chapter. Now that we have clearly understood how ownership passes, how delivery takes place, we are perfectly ready to move into our next logical topic, that is rights and duties of the buyer and seller, which we will be covering in our next video. Until then, see you and thank you.